The Affordable Care Act provision limiting the deductibles in small group health plans has been repealed, which we understand is good news for small business. My guest is Timothy Jost. He's a law professor at Washington and Lee University. Professor Jost, thanks for taking the time today. Talk about what this provision was doing in the Affordable Care Act and now how things are changed.
Well, that's basically right. The $2,000, $4,000 limit is in a part of the Affordable Care Act dealing with the essential health benefits, and it applied only to small group plans, and it applied to the deductible. The statute, however, also said that the limitations under this paragraph shall be, I'll just read it, shall be applied in such a manner so as to not affect the actuarial value of any health plan, including a plan at the bronze level. And as your listeners may know, health plans under the Affordable Care Act in this individual and small group market have to be either bronze, silver, gold, or platinum, with bronze being the least generous plans, with the plan basically paying 60% of total health care costs and the individual paying 40%. The problem is that it's very hard to design a bronze plan, almost impossible, with a deductible of $2,000 and $4,000. And so looking at those two provisions, HHS concluded that since the small businesses were supposed to be able to offer bronze plans, and since you couldn't design a bronze plan with a $2,000 and $4,000 deductible, they would waive that provision for bronze plans. Well, really for any plan where it wasn't practical to design the plan to meet that requirement. And having waived the requirement for bronze plans, since most small businesses don't offer really, really generous plans, it basically made it kind of a moot point.
So this enables small business owners to maybe shift some of the health care costs back onto the employee, right?
Well, yes, but again, they were able to do that anyway, since they were allowed to offer bronze plans in which the employee had to pay 40% of the average costs. And I should emphasize it's 40% of the average costs, and since most healthcare costs are concentrated on a very, very small number of people, what that effectively means is that most people get very little assistance, if any, from a $2,000 or $4,000, $2,000 for individual, $4,000 for family deductible plan.
And I think you said to the New York Times that, typically in this, what you call partisan paralysis in Washington, this kind of thing doesn't get done, but this was such a glaring error, I guess, that they had to do something.
Well, I wouldn't say it that way. I don't think it was a glaring error because it was possible to construe the statute so that you could, since the statute said that the actuarial value requirement trumped the deductible requirement, it was possible to construe the statute so that both parts would have effect. But I think maybe it'd be more accurate to say this was one area where opponents to the Affordable Care Act could claim a win by repealing part of the act without really changing the act at all, since it was already permissible to offer plans where the deductibles exceeded these limits.
My guest has been Timothy Jost. He is a law professor at Washington and Lee University. Timothy, thank you.
Sure, my pleasure.